Then there's a declaration that the person is of sane mind. The disqualification is again removed. The moment the person acquires the citizenship of Pakistan or sheds his foreign citizenship, the disqualification is again removed. The
साहब एक क्वेश्चन पहले भी पूछा है पर उसमें क्लैरिटी नहीं आ रही. इस 62 Article 62 applies pre-election, post-election, or at any time.
My lord, the way I look at it, election 63 applies at any time.
Yes.
62 applies only at the time of election because he shall not be qualified to be elected or chosen as a member of Majlis-e-Shura.
At the time of filing nomination.
Yes, my lord.
And a person files his nomination and his opposer submits some document before the returning officer that something, a decree has been passed against him, so he is not eligible to contest the election.
My lord, yes.
Is it your meaning?
My lord, my submission...
By the declaration of law, because opposer can file the application, his nomination form should not be accepted because he is not eligible to contest the election.
My lord, yes.
So what is the main interpretation of Article 62, whether it applies at every time, it applies before the election, or any time after election?
My lord, when your lordship looks at 62 and 63 and reads them together, because that's where I was coming to, after 1985...
And what is the difference between the opening language?
My lord, the opening...
person shall not be qualified to be elected, and if you look to 63, a person shall be disqualified from being elected. So there must be some distinction between the framers of the Constitution.
My lord, may I...
If I may interject, Mr. Makhdoom Ali Khan, and it may help you to respond to my lord as well. Somehow, as I see it, we've got bogged down in restricting ourselves to reading just a particular provision of the Constitution. And we seem to have forgotten the Constitution as a whole. What is the Constitution all about? What does it do? What are the fundamental rights? Article 17, more importantly. And we are going to a particular provision of the Constitution and just reading those and disregarding everything else. We're disregarding the history of Pakistan. We're disregarding the constitutional history of Pakistan in particular. We're disregarding the fact why these amendments were brought into the Constitution. We're disregarding the fact that the original Constitution has a greater sanctity than amendments brought there too, unless there are such amendments which enable to serve the people better. For instance, Article 19A, Article 10A. Now, nobody can say that these insertions have taken away something from the people of Pakistan. Rather, they have given something to the people of Pakistan, including Article 25A, compulsory education up to the age of 16. And these are, on the contrary, an insertion into the Constitution, and they have not been one insertion. They start with General Ayub Khan, and successively more and more encroachment into who I will determine will be fit to govern Pakistan. First of all, the initial question will arise, who am I to determine this? Why can't the people of Pakistan themselves determine? Oh, so what? Disregard how it came into the Constitution. Now you're stuck with the language of the Constitution. At least I am not persuaded to adopt that approach. I cannot forget the history of Pakistan. And unless you can say they are very beneficial things, we had given public notice in prominent newspapers. Not a single political party has come before us which has said, leave alone those who are not even in parliament, said that this is a good interpretation of the Constitution. So we come into, there is another aspect which I consider. There are things which are specifically mentioned. If, for instance, for theft, you mention a particular sentence, And if you say for a traffic offense or for some other offense, there may be a punishment. But for instance, the legislature forgets to mention for what duration. You can't possibly say, oh, I'll impose a punishment for murder here. There must be some logic, there must be some reasoning. The reasoning is, you destroy Pakistan, that's fine. You can contest elections for 5 years. But if you make a single mistake in the nomination paper, you're disqualified for life. Now, we are just stuck with the wording of it. Have we lost all logic and sensibilities? I mean, why are we not? Nobody's addressing that. I keep requesting that to be addressed, but we are just bogged down by this 62(1)(f) and the whole of Pakistan, because a general decided to impose that, has now got us thinking. Leave aside the constitution of Pakistan, we're just stuck with his language. So can we just what I really wanted from you as a constitutional expert was to expand our vision and not restrict it. And everybody's just working on those particular wordings. How does this mean? What does this mean? What does a court of law mean? Is it a court of plenary jurisdiction? Is it a constitutional court? Yes, those are necessary, important questions. But in context, in the order of priority, I would put it at number 10. Probably, if there are 9 other more important ones. Sorry, I went on a bit too long, but can you focus on those aspects?
Let me, my lord, that was in a way your lordship's observations connect and resonate with the question posed by my lord Mr. Justice Sayyid Mansoor Ali Shah. My lord, how? That the qualifications and disqualification as envisaged by the original constitution makers made perfect sense. That if you could disconnect them at a time, they made perfect sense because they dealt with 2 different subjects. In 1985, under Presidential Order of 14 of 1985, which we call the Revival of Constitution Order, all these changes came about with a minor change again through the 18th Amendment. At that time, where a whole host of disqualifications and qualifications were added. And when these were added at that time, virtually we lost the plot. And it would be difficult to say that 62 and 63 are now disconnected provisions. They are connected, they have to be read as a whole. Now, insofar as those amendments were concerned, they virtually were envisaging, as observed by one of your lordships in an earlier 7-member bench judgment, virtually a society of angels and parliamentarians who were probably even holier than angels to come into parliament. So there was a disconnect with real life, which reminds one of, your lordship's observations remind one of the quotes of Abraham Lincoln, that it has been my experience that folks who have no vices have very few virtues. So virtually introducing a society of people with no vices and few virtues. But my lord, in these qualifications and disqualifications, these very long list, there is a connection. And the connection is that you cannot read Article 62 without looking at Article 63. And even earlier, you could not read Article 62 and 63 without being conscious of the rights of citizens under Article 17 of the Constitution. This court has always been mindful not to disenfranchise people, that the right of people to form and join political parties is there, and a person has a right to contest elections. 62 and 63 both make inroads to an extent under that fundamental right. The inroads were sensible inroads when it came to the original 1973 Constitution, that we will not allow an insane person to be a member of the Parliament, that we will not allow an undischarged insolvent to be a member of Parliament, we will not allow a person who is not the citizen of Pakistan or is the citizen of another country to be a member of Parliament, that we require that persons should be at least 25 or 30 years of age, being National Assembly or Senate respectively, to be members of Parliament. and that none of those make an inroad into Article 17 of the Constitution.
So why are we interpreting it in this manner then? And then something has also been said that ordinary legislation is not a substitute for a constitutional amendment. Okay, you bring in a constitutional amendment, we strike it down. So our wisdom is paramount.
My Lord,
So we can do whatever we want to, not guided by anything other than our own vague ideas of morality.
My Lord, and that is the submission that two things you will not find. You will not find a judgment from the common law jurisdiction where by a declaration of the court, because this is not a declaration of Parliament, my Lord, Article 63 and
Will you concede that this is no disrespect to anyone, will you concede that the parliamentarians in Pakistan are tomorrow you are honest, you can be declared dishonest, out, in, it's up to me. Can I just write some few words of English language and that's that?
To give an immediate example, the US Supreme Court has a similar requirement: citizen, age.
Those are, you can physically,
Yes, yes.
you can checklist, yes.
Like we had in the 73 Constitution. Even when the US Congress sought to introduce new qualifications of this kind at a particular period of time, in Powell versus McCormick, the US Supreme Court struck it down. They said no. The Constitution has given a list of qualifications. Congress cannot add to that list of qualifications. That's where we stop. So the courts in other places have gone the other way. They've said, here is
Mr. Mazloom, speaking for myself, we'll have to, expounding the Constitution, we have to rely on the tools of interpretation.
My Lord, yes.
I look at the Constitution post 18th Amendment. To me, the dictator argument is out of the window because it is the 18th Amendment passed by the Parliament. So I need to give it a very serious thought in interpreting the Constitution. So every word to me is important. I could just disregard all the words and say this is not the Constitution. That cannot happen, even though I might disagree with the wording of it, but some meaning has to be attributed to it. I find the declaration personally making no sense, but I have to give it a meaning because I can't throw it out of the Constitution. I don't have the jurisdiction to do that. So having said that, you were at that moment explaining that the court of law could have criminal and civil both. Could you just resume from there and explain?
A court...
Can you also attend to a side query with what my Lord has just observed? My Lord is, with the greatest of respect, assuming that there will be redundancy to the Constitution. I would reframe it. There would be redundancy to the interpretation. The Constitution had simply said so. End of story. Fine. That argument would be. But it is how we interpreted the Constitution has said so. I don't know if that's a valid point or not.
May I, as counsel, mediate a safer course for myself by saying, by saying,
No, please.
No, my Lord, because that's
you see,
the legal duty or obligation owed by the candidate for election to another person or the violation of the latter's legal right or privilege. Then a paragraph 25, if your Lordship may see the last 4 lines on page 437. Because here their lordships identify what kind of declaration they are envisaging. Therefore, the consequence of permanent nature, that is incapacity, following a final and binding decree of a court of civil jurisdiction, is the ordinary and lawful outcome of civil litigation.
So Samila Baloch actually clarifies what declaration we're talking about. It's arising out of a civil jurisdiction, and dealing with civil disputes of two parties.
Yes, my Lord. And therefore, my Lord, if they had not, their lordships had not observed that, the disconnect between 62 and 63 was impossible. Because if this was a declaration by a criminal court convicting someone...
it means then a decree must be keeping in view Article 62 in mind.
That is what they envisage, as your Lordship sees.
How it can be when a person is applying for the election, at that time Article 62 comes.
Yes, my Lord. Because your Lordship see, they say
So
that...
a prior decree can be...
Yes, they say that, my Lord, in paragraph 26, if your lordship sees the quotation mark where 63 is reproduced, and 63H in particular, after that say we have already observed that a conclusion about a judgment debtor having character failings specified in Article 62(1)(f) of the Constitution that emanate or can be derived from a final judicial declaration would cause the permanent incapacity of a candidate for elected office. Again, declaration of a civil nature. And if your lordship turns the page, your lordship will see paragraph 29 on page 441. Under Article 62(1)(f) of the Constitution, the judicial declaration by a court of civil jurisdiction against a candidate for election to Parliament would adjudicate misconduct of the candidate that has not resulted in his criminal conviction and sentence for more than 2 years by the competent court. Accordingly, we now consider the argument that a civil law declaration involving personal flaws mentioned in Article 62(1)(f) of the Constitution should not carry ineligibility for contesting election that is longer in duration to the disability provided in Article 63(1)(h) of the Constitution. Then they mention 63(1)(h) of the Constitution, my lord, from paragraphs 30 to virtually paragraph 32. Their lordship cite the previous case law from paragraph 33 to 35, and on page 444.
So Mr. Makhdoom, one thing that we could actually rely on Samuel Baloch is to clear ourselves as to what declarations we're talking about. So declaration arising out of civil jurisdiction, which is an outcome of civil litigation. So several other declarations which are not arising from civil litigation or civil jurisdiction are out of the picture.
Yes, madam.
So ek to wo limit ho gaya na. So one benefit that one could probably draw from Samuel Baloch is that the nature of that declaration is quite obvious. The second question would be, of course, the duration, but this is quite clear.
And my lord, that immediately leads to two submissions. Your lordship, in my research, I have not been able to find out, but your lordships may be aware better than me, that I could not find a case from any common law jurisdiction where, as a result of a civil liability and a decree of a civil court, a citizen is denied the right to exercise or the protection of a fundamental right guaranteed by the Constitution for the rest of his life. Criminally, in criminal law, it may happen.
About a banking case.
My lord.
How about a banking case?
My lord, yes.
The banking case, he's declared
my lord, yes.
debtor.
Now, the question is,
the law says that if you're a debtor, till you are a debtor, your disability is there, till you clear the debt.
correct, my lord. Your lordship is absolutely right, and that is why your lordship will find that insofar as that is concerned, that is reflected in Article 63 of the Constitution. And Article 63 talks about, one, the debt having been outstanding for a particular period of time, and till such time that it is paid. The moment that debt is paid, debt is removed. I was talking of a situation where a civil liability results in a person being deprived of his right forever. Because in this case, my lord, in the case of a debt, as your lordship has rightly identified, or utility bills not being paid, the moment they are paid, the debt is met, the person is eligible. In this case, what does he need?
In this case also, they say that till that decision is there, that decision, set aside that decision, and your disability goes with it.
My lord, their lordship say that determination taking place from a court of final determination. Let us say that, first of all, my lord, which court is capable of granting a declaration under the civil laws of the country, whether it be a Section 42 court or a Section 9 court or even an Article 199 declaration, that a person is sagacious, mean, righteous, non-profligate. Because your lordships generally grant declarations about a legal title or a legal character. There is no civil court in this country which can grant that. My lord, now let's turn to the election laws. The civil court under the election law.
One question, Mr.
My lord.
The two questions rather. One is that whether the civil court has the jurisdiction to grant negative declaration, and number two, whether that court has the jurisdiction to fix the disqualification of a candidate
My lord,
for a certain period or even for life, whether the court has power.
My lord, my submission would be that the reason why a civil court can't do that is twofold. Number one, the civil court is unable to do that because of the language of section 42 and section 9 and article 199. And the second is that such an issue, when it arises particularly in the context of an election, because the issue of qualification or disqualification will only arise in the context of an election, that jurisdiction is completely ousted by Article 225 of the Constitution and the judgments of your lordship. Your lordships have said no election will be called in question. The meaning under Article 225 of the Constitution, and your lordships have said in Javed Hashmi's case that election starts from the time the Election Commission notifies the schedule till such time that a candidate is declared, returned or elected. The decisions of the election tribunal, your lordship have said in Raza Hayat Hiraj's case, cannot be called in question even in a writ petition.
फिर तो कोई prior decree भी cannot be used.
My lord,
Suppose there is a prior decree before the start of election that cannot be used in the.
my lord, the prior decree will only say whether I have paid my debt or not. Now, in that case, as my lord, Mr. Justice Yahya Afridi identified, there will be a disqualification attracted under Article 63 of the Constitution. No declaration under Article 62 of sagaciousness or righteousness. My lord, which, your lordships with your vast experience in civil law, which civil court, when passing a decree, even in a banking suit, and says this money is outstanding, then goes on further to declare that this person has ceased to be sagacious,
So that's the question. Can you just go back, Mr. Makhdoom?
My lord.
We cannot attribute redundancy to the Constitution, even though it's quite clear that there's no such declaration that can come from any court. But we have to give meaning to because we can't just throw it out. So making an effort to giving it a meaning, this paragraph is crucial in Samiullah, that the declaration they're talking about is arising out of civil jurisdiction, inter-party litigation. So, for example, there's a case where a sale deed has been struck down as being fraudulent or forged. Now, there it has been, as a consequence, we understand that that person has committed fraud because he came up with a fraudulent sale deed. That is a bit of a construction that we have to do just in order to justify this declaration given in the court. Having said that, all the other declarations which are coming in through original jurisdiction and the writ jurisdiction not arising from civil jurisdiction are out of the canvas, right? So let's first specify that the declaration we're talking about is inter parties arising out of civil litigation.
Right.
Now, in the absence of 232, we would have had to construct what is to be done. I'm just saying that legislation could, not justifying 232, but legislation could say that for the purpose of election, such a civil, such a decree which is arising out of civil litigation could have a time frame for purposes of election. So the question is, can legislation put a time frame on this declaration? Could that be possible? Not the way it's worded in 232. My question to you is that, first of all, Samiullah Baloch helps us identify that which declaratory decrees we talk about, which declarations are relevant. Declarations arising out of civil jurisdiction, which are inter parties, number one. Now, could legislation, not the way it is done today, but could legislation say that this declaration will continue forever for between the parties, but for the purposes of election will have a time frame?
My lord,
such a legislation is not the way it is done now in 232, but could such a legislation be possible to say that a declaration inter parties arising out of civil litigation for the purposes of election would only be for 5 years, even though between the parties it will remain forever till it is set aside, but for the purpose of election? Could such legislation take place?
my lord, that was a bit later, but may I address it right now? My lord, when your lordship looks at 62(1)(f), the constitution makers under the 18th amendment do not say that this is a declaration of a civil court. They say no declaration to the contrary by a court of law. A criminal court is as much a court of law as a civil court. Now, if your lordship reads a court of law as a court of law, a court of plenary jurisdiction, that would include courts both on the civil and criminal side which decide cases after recording of evidence. And in that, if your lordship does that, then 63 and 62 will have to be read together. There's no way one can read them differently. My lord, may I just preface this a little further? Sure. My lord, a question has been asked and repeatedly that, and my lord, Mr. Yahya Afridi asked that again yesterday. Why have two lists? Justice Hilali asked the same question again. Why have two lists? What's the difference? My lord, the two lists made perfect sense under the original 1973 Constitution. The list of qualifications was that you should be a citizen of Pakistan. For MNAs, you should be 25 years of age. For senators, you should be 30. And that is where the qualifications ended. All three were qualifications. The disqualifications were that he is of unsound mind, that he is an undischarged insolvent, or he ceases to be a citizen of Pakistan or acquires the citizenship of a foreign country. When your lordship looks at them, person loses sanity, or the person loses citizenship, or a person becomes an undischarged insolvent. The moment the court declares that person as insolvent, then the disqualification is removed. The moment there's a declaration that the person is of sane mind, the disqualification is again removed. The moment the person acquires the citizenship of Pakistan or sheds his foreign citizenship, the disqualification is again removed. The
साहब एक क्वेश्चन पहले भी पूछा है पर उसमें क्लैरिटी नहीं आ रही कि 62 Article 62 applies pre-election, post-election, or at any time.
A clearly unprecedented approach, clearly unconstitutional approach, then your lordships could have taken even notice yourself. But 232 is an approach which is justified by the practice of legislators the world over. What happens in the United States when a statute is struck down by the court? It's legislatures or the Congress at times passes another statute. They compel the court to revisit their previous judgment. In United States, legal tender or paper currency was held to be unconstitutional.
But Mr. Makhdoom, leaving aside 232 would also be a bit of a challenge in the sense that this provision, as submitted by Mr. Faisal Siddiqui, has actually been brought in to nullify Samiullah Baloch. And we are examining Samiullah Baloch. There is a legislative intervention to nullify the judgment. We will not take any notice of that provision.
My lord, may I point out, if your lordship overrules Samiullah Baloch, and that is what Mr. Faisal Siddiqui also submitted, if your lordship overrules Samiullah Baloch, then that conflict disappears. There is no longer a judgment of this honorable